Hey, and good morning, everyone. Welcome to UroNurse. We meet every Saturday at 9 a.m. Central Time. If you're joining this by YouTube, great. We enjoy having you on. Be sure to hit that like button and that subscribe button. And if this is your first time seeing our program, be sure to visit our website at uronurse.com, where you can find out more about the program. And also, this is the best way if you want to see previous programs. This is our 25th episode. So if you want to see previous episodes, go to our website. They're all up there. They're all hosted on YouTube. Now, during the presentation, if you have any questions, feel free to go to the Q&A box and go ahead and put those in. Beginning of the show, we do take any general questions. So if you have any questions about the show or any general urology questions, this is your chance. We've got a great group of panelists for you to ask. Today's program is really going to be interesting. We've got Tony Sam joining us today. He's a defense attorney, and he's going to be talking about medical malpractice. And let's get right to our great group of panelists here today and get a little bit of a introduction. So Tony, why don't you take it away and introduce yourself?
Hello, everybody. My name is Tony Sam. I'm a partner at Cunningham, Meyer Vedrine, where my primary practice focuses on medical malpractice defense, representing doctors, hospitals, nurses, you name it. If they're a healthcare provider, that's what we do.
Great. And we're glad to have you. And for those that are joining us for the first time, I know there's a few people who signed up this time. So my name is Vic Sinise. I'm the host of the program, and I'll be guiding us through this whole journey. Lori, why don't you introduce yourself?
Hi, my name is Lori Atkinson. I'm a certified urology nurse. I've been doing this for 24 years now, currently working for Northwestern at Delnor in Geneva, Illinois.
Great. And John, go ahead. Give us an introduction.
Hello, everyone. I'm a private practice urologist who wants to pay it forward by sharing my little experience in the business of medicine to benefit my colleagues. I have a strong interest in coding, billing, compliance, efficient practice management, marketing, social media, and online reputation management. I look forward to this great exchange.
Absolutely. Fantastic. Guys, I couldn't do it without the great panelists that we have. I'd like to welcome all of our attendees that are showing up. We got quite a few names I see from before and some new ones there. So great. Welcome, Diane, Leo, Mary, Melanie, Neil, Rebecca, Robin, Shilipa, and Susie. So welcome. And I know we'll be getting some more, and some are over on the YouTube program too. Now I don't see any questions coming up, so nobody must have any questions. So I think we'll go into the next part of our program, and that will be to share some favorite stories. Lori, you said you had a favorite story you wanted to share. I'm going to let you kick it off.
All right. Well, it's a favorite story that's actually going on right now. So we like to have fun in our practice. And some of my MAs for my birthday back in October decided to get me a life-size model of a penis with confetti in it.
Of course.
So it's been sitting in my cabinet since my birthday, and one of my coworkers and I decided, all right, let's have some fun with this. We're going to have some fun. So what we're doing is we are calling it Finding Peter. And so we hide it around the office, and then we have a little note on it that says, if you found Peter, please hide it for the next lucky participant. So it's now, mind you, we do not do this in front of patients. We don't want a lawsuit, right, Tony? So it's been going around the office, but the one day last week, we had kind of a head honcho of the hospital come in, and so right away, I'm like, oh my God, where's Peter? I don't want this thing to pop. And somebody goes, well, unless she's going to use the microwave, it's okay. So the last I heard where Peter was, we gave it to we put it on one of the doc's desks, and it is missing again. So we don't know where it's at, but we like to have fun.
That's why we're in urology, because
that's right.
we go into some crazy things. I do have a story I'm going to share. This not a funny story. This I think is more serious, but it's interesting. Early on in my career, and those that have watched the program know that one of my big specialties is erectile dysfunction, and I got into it early on, pretty much when it started to come out that all these injections were suddenly available for injections, for erections, things that were available before Viagra came around. One of my patients was a young MS patient, probably late 30s, early 40s. And MS to me is one of the most devastating things because it hits you in your early adulthood. You're just getting your life going, and all of a sudden you got this lifelong sentence that you're going to have. And one of his issues was erectile dysfunction, and he was functioning well. I mean, he walking, sometimes he use a cane, but he was getting around okay. But he had gotten married, and one of the things they really wanted to do was start a family. And of course, his erectile dysfunction was interrupting with it. And so worked with him, got everything working. And back in the early days, you couldn't go to the pharmacy. All the stuff was custom made. So he was a pretty regular in my office. We got to be pretty friendly. And so he would come in and, to get his medication, and he'd be kidding around with me. And he'd say, boy, if my wife ever gets pregnant, I can tell you if I have a son who I'm going to name it after. And I go, oh, yeah, okay, sure. So one day he comes in, he's got a big smile on his face. He says, hey, my wife's pregnant. I go, hey, that's great. I'm really glad to hear that. So goes on and comes back. And next time I see him, he comes in, he's got baby pictures. And here's this cute little baby boy. He goes, meet Victor. So, you never know what kind of influence you're going to have on patients. But so there's somebody out there named Victor, thanks to what I did is my little part of urology. But he's a great guy. I still keep up with him. Unfortunately, his disease has progressed. Now he's in a wheelchair, and it's a sad story. But I think Victor's got to be about 18 years old now. So great story for me anyway. John, did you have anything to share, or Tony?
Yeah.
I'll open it up. Go ahead, John.
Actually, something happened just yesterday. Some of the, as you know, aside from erectile dysfunction, well, I guess in urology, it's just a feel good type of a lifestyle. A lot of things that we do, it relates to lifestyle, and erectile dysfunction is certainly one of those major ones. I also, aside from doing a lot of the number one vasectomist in Arizona by volume, last couple of years I did about 2,300 vasectomies. Aside from helping patients come worry-free, I also help patients make America pee again. And there's about a 30 to 40 million men problem in the US. That's called BPH, benign prostatic hyperplasia. One of the surgeries that I do is the traditional gold standard surgery, TURP, transurethral resection of the prostate. This gentleman that I saw yesterday was in his early 50s, had horrible trouble urinating. He had to just try to drive 2 hours away from here. He had to carry a bottle in a car so that he could void into it. He had such horrible frequency. So I did a TURP procedure on him about 4 months ago, and he came back and he was ecstatic. Couldn't stop thanking me. His symptom score greatly decreased, and he said, now I can just drive anywhere. I don't have to worry about where all the bathrooms are. I have a strong stream, no frequency anymore. My nocturia is going down. I only have to get up once a night. And he said, I'm not sure if I get up because I'm up already and I have to pee, or do I just simply go pee because I'm already up? So he was extremely grateful. And at the end of our conversation, he started tearing up. He said, Doc, I can't thank you enough for what you did for me. I mean, these are the interactions that make you keep going. Just like you have so much impact on people. So everything that we do impacts another person and probably their families, because now he's going to be able to continue to work and pay for my retirement and pay for his family's survival.
Yeah. No, it's a true story. We don't know what impact we make all the time, but sometimes it's nice when patients give you that feedback. Did you mention what procedure you did?
TURP. Yeah.
TURP. Yeah. It's a lifestyle change for people, and you just underappreciate sometimes what we do. And when we get into trouble, legal trouble, we underappreciate sometimes, I think, what our legal friends can do for us. So I don't see any other questions coming through. So Tony, if you're ready, I'm going to let you switch over and
get started.
Share and start your talk.
All right. Well, today we're going to be talking about minimizing the risks of medical malpractice lawsuits from providing patient care. And I want to start out with a disclaimer because, of course, every lawyer starts out with some sort of disclaimer. Today, I'm going to be talking generally about concepts that affect patient care, and I may not be providing specific legal advice that's tailored to your particular situation. But the wonderful thing is that there are a bunch of resources out there. Here in the state of Illinois, we have the Illinois State Bar Association. We have Find Lawyer programs that you can contact, and they'll be happy to put you in touch with people who can answer your specific questions. And I'll take some questions today at the end of the presentation. If you have specific legal questions that you want some tailored advice to, I highly suggest that you contact a lawyer in your state, and we're happy to talk with you and discuss issues that affect your patient care and outcomes. Today, we're going to be focusing on 5 main areas, some of the risks of medical care. We're going to talk about an overview of medical malpractice, and then we're going to get into the CDC. We're going to talk about continuing education and training, some documentation and communication, because in my experience, those 3 things are ways that we avoid medical malpractice lawsuits. Well, we all understand that there is risks associated with providing patient care. Most patients come to see you. They seek out your services to keep things from getting worse, to prevent things from happening, or for general health care maintenance. The problem is that people are not like automobiles where you can just hook them up to a machine and they'll spit out a code that tells you you need an oil change, that you have a blockage in a certain type of area. We do have medical instruments that tell us what's going on inside of a patient, but it doesn't always tell us how to fix them. For example, a doctor or nurse could provide treatment to 100 patients with the same condition. They know it. They've seen this 100 times, and 99 patients can act one particular way with the same course of treatment, but you have that one patient who doesn't necessarily have the same outcome, even though the healthcare provider did everything the exact same way he or she did not the 99 other times. And that's sometimes hard for individuals to understand, that you're practicing medicine and not necessarily guaranteeing an outcome. You may not be able to fix what's wrong. You may not be able to cure a particular ailment because bodies act differently, even if you provide the same type of treatment. Here in the United States, we unfortunately experience some medical errors. Those things happen due to maybe an act by a healthcare provider or inactions by healthcare providers. It could be a problem with a system at a facility or a combination of factors. One of our goals is to minimize those types of interactions with patients because in the US, we suffer about 250,000 patient deaths each year. And so all of us should work towards having no preventable harm to patients. And we'll talk about some of the ways that we can do that. But these 250 or so deaths or those cases that involve medical malpractice are usually situations where the patient or the patient's lawyer thinks that there was some sort of medical error. Well, let's talk about some of the overviews of medical malpractice. Everyone thinks that, if you file a lawsuit, it has to have merit. That's not true. In America, anybody can file a lawsuit as long as you have the required filing fee or a fee waiver. Clerks in your county or in your district where you live, they will accept the court papers, often called a complaint. That's the document that the patient files against the healthcare provider that outlines what they believe went wrong in their care. And as long as they have a filing fee, the court is required to take those complaints. I have to tell you that just because a patient files a complaint doesn't mean that the healthcare provider did anything wrong. The whole goal of the lawsuit is to have your day in court where the judge or the jury in your respective state or in your respective case decides the outcome. Some states create a little bit of a bar that stops certain types of cases from moving forward. For example, in Illinois, most medical malpractice lawsuits are required to have what we call a reviewing healthcare professionals report. What that means is that the patient has to go find another healthcare professional, likely a doctor or a nurse, depending on the type of case, and they have to have the facts of those cases reviewed with those individuals before they can proceed substantively with their case. But some patients don't secure those reports and file suits anyway. Why? Because the court is required to accept the complaint if they have that required fee. Let's talk about some of the reasons why patients sue. One of the reasons patients sue is a negative outcome. Sometimes things happen in patients' care and they want someone to blame. You were supposed to fix my loved one. You were supposed to fix me, and you didn't. And so they file those lawsuits because they had a negative outcome. We anticipate that in providing medicine that there's no guarantee, but even if there's a negative outcome, that doesn't necessarily mean that there was malpractice. A big one is a negative experience. We've all seen that television show House, and Hugh Laurie he's a beast when it comes to his medical judgment, but he has a terrible bedside manner. And oftentimes patients sue because they have a negative experience with the healthcare provider. Maybe you weren't as sensitive to a patient's pain complaints, or maybe it appeared that you were brushing them off, or maybe you said something that made them feel a certain type of way when you were interacting with them. That negative experience could negatively impact your case. I've had doctors who had negative outcomes with patients go in, sit down and talk with the patients one-on-one, explain everything. And even though they had that negative outcome, the patient decided not to sue because they felt that the doctor was there. They had a good bedside manner. They felt that the nurses were there and communicated with them. And so you have to make certain that you're communicating appropriately with the patient. And if you're in a situation where you think you know some things that happen in the patient's care, you might want to talk with the doctor or other healthcare providers and determine what type of strategy you should have in terms of communicating with the patient regarding their results. And then, of course, one of the big ones is money. Some people are litigious because they intend to make money. One of the sad facts is that 97% of cases resolve without a trial, and that is by way of motions to dismiss or motions for summary judgment. That's a ruling without necessarily a trial. And some resolve by way of settlement. And so some lawyers and some patients believe that they could recoup substantial funds as a result of filing lawsuits. We want to talk about allegations versus liability. Some people get freaked out. I mean, you've never been involved in litigation before, and you get a complaint against you, and it causes some level of anxiety or angst. But a complaint is just a statement of what the patient's claims are. They're not facts. They're not things that have been proven. They're not admissions necessarily against you. It's just what the patient's story is about what happened. What most of us look forward to is what we call the judgment. That's the decision on the merits of the case. That's when the court decides who wins and who loses. So just because you have a complaint filed against you doesn't necessarily mean that you did anything wrong. We look forward to the judgment because that happens after the trial. That happens at a summary disposition, and that usually details who wins and who loses. I'm going to stop for a moment and plug this insurance. You got to have some insurance. Most practitioners recognize that insurance helps protect your ASS, ETS. It protects your assets. And so you need to make certain that if you're providing patient care that you have medical malpractice insurance. One of the great things is that many of you work in healthcare institutions or you work in offices that have insurance for you. And some of you who don't, you want to make certain that you reach out to a reputable insurance company and secure your medical malpractice insurance. Here's why it matters. With medical malpractice insurance, the insurance company actually hires a lawyer for you. They hire a lawyer who will represent and defend you from the moment the complaint's filed until the judgment is entered at no cost to you. You don't have to pay for those lawyers, and so your insurance company picks that up. The second aspect is that it usually covers a judgment to a certain dollar amount. Most medical malpractice insurance policies are $1 million, maybe $3 million, maybe $5 million, depending on what type of practice setting you're in and what type of coverage you request. That's important because if a patient has an outcome, a negative outcome, and they sue and win, you want to have some insurance coverage that will pay the judgment so that you don't have to risk your kid's college fund, your house, your car, things of that nature. So I often say I get insurance to protect me. I want my assets to be secure. I want the things that I work for and that I built my life to develop to pass on to my children and their children. So getting insurance matters. Make certain you have some. So let's talk about the overview of a medical malpractice. If you are ever involved in a situation where a lawsuit's filed against you, take a moment, take a deep breath. Some people can go 20, 30, 40 years in practicing medicine or in nursing care and never have a lawsuit. Some people get hit within their first 4 years with a lawsuit. The goal is not to freak out. What you should do is if you receive court papers related to a lawsuit, you should contact risk management. If you have a risk management facility or a risk management group at your practice, at your institution, contact risk management. I say contact risk management because they know what they're doing. It's in the name, risk management. If there is a risk to something going on in the practice or in the group, the risk management professionals know what to do. They know to contact the insurance company. They know to contact the lawyers, general counsel for your practice group or hospital. They know what to do. Don't wait. People think that ignorance is bliss. It is not. If I ignore the papers, they will go. They will not. They filed a lawsuit. They're coming to seek their day in court. You want to get the risk management team involved as soon as possible. If you don't have a risk management team, make certain you have that insurance and contact your insurance carrier because you might be entitled to representation at no cost, and your insurance agent and your insurance carrier will help work through those things. If you don't have a risk management team, you don't have insurance, you need to contact yourself a lawyer immediately because you want to make certain that you protect your rights because the failure to timely respond in some situations can result in default judgments. So the faster you get the lawyer involved, the better off you typically are going to be. So I tell you, don't ignore the court papers. You don't hide your head in the sand because, of course, ignorance is not bliss. It's just ignorance. So make certain that you get those things and you get those balls rolling. Don't contact the patient. Some people think that if they contact the patient, that the outcome in the case will be better. No, it won't. And as a matter of fact, the conversations that you have with the patient are discoverable. So don't contact the patient because nothing good will come of that. You're not going to convince them to drop their lawsuit to make it all go away. Don't contact the patient's attorney. I can't tell you how many times I get a case where the doctor says to himself or the nurse says to themselves, if I contact the patient's attorney, I can convince them to make it go away. They have a financial incentive to keep the case going because they don't collect money unless they win. So you contact the patient's attorney, and then they start asking you about the care you rendered. They start asking you things, and you start making admissions that ultimately may be used against you in a court of law. So you could be your own worst witness. So make certain you don't contact the patient's attorney. And then the last thing that I say on this issue is don't access the patient chart. Most of us recognize that now we are operating in the electronic medical record, the EMR type of situation. Well, every time you open up a patient's chart, there's usually some digital log that shows what you went into, what section of the chart you might have accessed. And you shouldn't access a patient's chart for that reason. And for also there are HIPAA reasons why you shouldn't be accessing a patient's chart, particularly if you're not providing patient care. And if you're involved in a medical malpractice lawsuit, you're likely not providing patient care at that point. So you can get a copy of the patient's chart directly from your lawyer. You can get one from risk management, and those types of entries are typically benign as far as discovery is concerned. And then some of you might be tempted to make some changes to your patient records, and we'll talk about that in a little bit, but that's a big no-no as well. So let's talk about medical malpractice for health professionals. Healthcare malpractice is a form of professional negligence. And in Illinois, we have 4 basic elements. We got a duty, we got a breach, we got causation, and we got damages. One of the greatest things about being in the United States of America is that the party who files the lawsuit typically has the burden of proof. It's the accuser, the one who makes the accusation, that actually has to prove it. And in this case, the patient would have the obligation of proving each of the elements of a professional negligence, a healthcare professional malpractice case. And they have to prove each and every one of them. If they miss one, they lose. So let's talk a little bit about that. Every healthcare professional has a duty to their patients. And so I typically ask, is there a professional relationship between the healthcare provider and the patient? If the answer is yes, that means that you have a duty. Since the pandemic, we've seen a lot of changes in the healthcare field. Some of us are doing telehealth. Some of you are doing curbside consults. You're dealing with your families and friends. Well, you have to be careful what you say and what you do, because in each of those instances, you're creating or could be creating a professional relationship that could trigger your duty. And a healthcare provider typically has a duty that we'll define at law. A healthcare provider has a duty to comply with what we call the standard of care. I want to tell you right off the bat, the standard of care is not perfection. It's not what a majority of nurses will do. The standard of care is what a reasonably careful nurse would do or not do under the circumstances as shown in that particular case. So you have to act as a reasonably careful healthcare provider and do the things that you're supposed to do as dictated by the circumstances in each particular case. And so what that usually tells us is the standard of care may be different depending on the type of procedure, depending on the type of care, even depending on the type of healthcare professional. We're going to see that your standard of care is typically going to be based on your clinical judgment. We need somebody who's in the same field as you. So if you're a nurse, there needs to be some expert testimony from another nurse regarding what the standard of care is. So they'll need some expert testimony that tells them this is what a reasonably careful nurse would do or would not do under the circumstances in that particular case. One of the great things about having an insurance carrier help you through this process is that they typically hire nurses who will come in and testify on your behalf at the time of trial. Those nurses will take a look at the care that you provided, and they will be able to tell whether you complied with the standard of care or whether they think that there was a breach, a violation of the standard of care. And then they'll have some options about how to resolve those types of cases. Understand this, a negative outcome doesn't necessarily mean a violation of the standard of care. What we look at is what happens under the facts and circumstances, what we knew at the time you provided that care and treatment, and whether your actions were reasonably careful. I often say there's no Monday morning quarterback. We don't look at the outcome and try to determine whether you comply with the standard of care. That's the wrong way to look at it. The appropriate way to look at it is while your boots were on the ground, while you were in the patient room, what information did you know or have access to, and how did that inform your decisions regarding patient care? So we have the element number 3 is causation. We want to know whether or not the healthcare provider's actions or failure to act caused an injury. And not all deviations from the standard of care result in a patient injury. Like if maybe there was no written emergency plan. Well, does that really cause an injury to the patient? Odds are Probably not if you followed all the steps that would have been included in a written emergency plan. Typically, on the subject of causation, you're going to need expert testimony. You're going to need somebody to come in and say, well, if they had done this, this wouldn't have happened. If they had not done this, this would have happened. And so you'll need some expert testimony as to causation as well. And then the final step is to prove damages. Was the patient harmed? Did the patient suffer some physical, emotional injury as a result of what happened to them? Most healthcare providers are not at risk of losing their personal assets because they have some measure of insurance. Or if you work at larger hospital systems, they have primary coverage, then they have excess coverage. And what that means is typically the hospital will pay the first maybe $3 million, $5 million if there's an adverse judgment. And then they have insurance carriers that provide additional coverage, sometimes to hundreds of millions of dollars. So it really depends on your type of practice. But what the patient's really after is something that will make them whole. In our society, we don't necessarily give the patient their bodies back or their sutures back, because if somebody suffers an injury as a result of malpractice, you can't really fix that. You have to give them money to help compensate the value of the injuries that they suffered, whether it was pain and suffering, a lost limb. We try to give them money to help compensate or make them whole as a result of what happened to them. So you can minimize your risk of being involved in a medical malpractice lawsuit by following these 3 steps. CDC, continuing education, watch your documentation, and of course, communicating. So let's get into them. We know that every one of you as a nurse and even our doctors, we're required to undergo continuing education. For nurses, you need to get you are up for relicensure every so often. And so you need to have those continuing education units in order to qualify for your relicensure. I like continuing education because my whole goal, even in the practice of law, is to get smarter. The things I knew 12 years ago when I started practicing law have changed. We have new Supreme Court cases. We have new amendments to the rules of evidence or civil procedure every other year or every year. The same thing happens in nursing. The things that you all did 25, 30 years ago, for some of you, may not necessarily be the same things that you do today. How do you find out about that? How do you find out about changes or new developments in nursing or in medicine? You have to continue to educate yourself. You have to go to these continuing education courses and you have to pay attention to what's going on there. I often say pick continuing education courses that you will use. If you're a urology nurse, probably not a good idea to start taking ophthalmology continuing education courses. You're not going to use that. So pick things that are specialties in your area, things that you're actually going to use that are going to help you in your particular practice. The second thing you can do is if you don't know something in terms of patient care, something that you're asked to do by a doctor, you better make certain that you ask. You don't know, ask. People are there to help. There are other nurses out there who will be willing to tell you about things that are going on or things that you need to do. So if you don't know, ask. And the third thing I'll say is to share your experiences. At my firm, we get together as lawyers and we often go out to lunch to share our war stories about cases. We do that because I can find information that will be useful in my case by talking to other lawyers. The same thing happens too at your facilities. So if you have an experience with a patient or with a doctor or a particular procedure, you want to share those experiences because they could come in handy. They could be something in the back pocket of another nurse that they'll use when they encounter those same situations. So experience matters. We'll talk about documentation in a little detail. We'll talk about some education versus practice and litigation. We'll get into some of these electronic medical records issues, talk about policies and changing records. No, don't change the records. Let's talk about documentation. When I get involved in a medical malpractice lawsuit, I I have a way that this document comes out that looks entirely different than what the healthcare provider has at the station. So you all receive education. And when you go to nursing school, what they tell you about documentation is great. Some of you probably have heard, if it wasn't documented, it wasn't done. And I often say, really? So if I failed to write down in the nurse's notes that the patient had an above the knee amputation, does that mean he really didn't have an above the knee amputation? I mean, he walked out with one leg. He had an above the knee amputation, but you've been educated. You've been told that if it wasn't documented, it wasn't done. And then you go into a deposition and you say, yeah, it wasn't done. No, that's a trap. See, the whole point of if it wasn't documented, it wasn't done is to tell you the importance of documentation, to give you a guidepost to make certain that you write down things that happen in a patient's care. But let's be practical. You can't write down everything. It's not like you have some stenographer or court reporter there transcribing every word that takes place between a patient. Instead, your documentation is a summary of things that happen in a patient's care. And so don't buy into the concept that if it wasn't documented, it wasn't done, because there are circumstances and situations where things don't get documented and we know things were done. We might not be able to tell from your nurse's notes, but some hospitals have flow sheets that show when you administered medication. Some automatically record when you walk into a patient's room or when you access things in the patient's chart. So you may not be able to write down everything that was done in the patient's care, but that doesn't mean it wasn't done. So take some time, talk with your lawyer, talk with your risk management department, and see if that really is true regarding that patient's care about your documentation. We know that there's some practical realities when it comes to providing patient care, and you're not able, because of time or resources, to be as thorough in your documentation as you would like. It happens every day. Because if a patient starts to code in a room, the last thing you're going to be like, well, let me get this documentation done real quick while the patient's coding. No, you're going to go and deal with that emergency. And so there's oftentimes that there's a delay in writing your notes, and that's okay. But you should devote that last 5 minutes of your day or that last 15 minutes of your day to make certain that your documentation is done for that day. Because the longer you get away from it, the less likely you're going to be able to remember the pertinent things that happen in patient's care. But understand that we recognize the practical realities of patient care, and you're not going to be able to document everything. Here's point number 3. Most healthcare providers don't document for litigation because you don't think that you're going to get sued. Of course, no one does. You don't wake up this morning and be like, you know what, I'm going to go in and provide some care and I'm going to get sued today. That doesn't happen. So you never thought a lawsuit was coming in a patient's care. So you didn't know that if you had written this one sentence or if you had said this one thing in your note, that would have been something that would have been useful in litigation. So you don't document that way. I represent a lot of healthcare professionals who are involved in a medical malpractice lawsuit. And afterwards they say, oh my God, I really learned how to document from being involved in this lawsuit, because now I know what people are really going to say when we get involved in a lawsuit. So you want to be cognizant about the things that you write down. You should write down the major things and important things in patient care. Some of the things that I like to see in clients' charts: you discuss risks of procedures, you document medication, you document people who refuse to follow your medical advice or the recommendations of a doctor. If those things happen, you should make certain that they end up in somebody's note. So we document so that we can prevent medication errors. If a patient has an allergy to a medication you don't want to give them, make certain you put that in the note. Or sometimes there might be contraindications, or there might be negative outcomes or side effects if you mix certain types of medication. So we want to prevent medication errors. Oftentimes that should be taken care of by the pharmacy or pharmacist. But if you as a nurse or you as a healthcare provider don't put that in the note, that's a problem. The second thing we have is communication errors. You want to document so that you can communicate what happens. Look, doctors are not always there with the patient to see that they complained about swelling in a leg or they had pain or discomfort in a certain area. And so communication with other healthcare providers is important, not just for communicating with doctors, but communicating with other nurses. You are the front line oftentimes in patient care. And you talking with each other about what happened on your shift, about what happened in these with this patient during those handoff sessions can be very, very, very important. And so you might want to communicate with other healthcare providers, do your verbal sessions, but you also want to be able to document that in the file because it could be important for the person who comes on behind you, whether it be a nurse or doctor coming back and looking at the file. And another reason you document is because what you document in the patient's file is typically going to be a reference point for that patient's condition at that specific moment in time. And so it's important to know what's going on with the patient's care. We have electronic medical records, and I say data and metadata. There is so much happening nowadays with the electronic medical records. Most patients' attorneys want to have access to those because they think that there is some interesting thing that happens in those records, and they want to have access to those things. So you want to make certain that you recognize that there are electronic medical records that actually produce audit trails. They produce information showing who accessed the patient chart, when, and what they did. So you should only access the patient's records when you need to provide patient care, and be cognizant about that. I can tell you that oftentimes I see healthcare providers go back into a patient's chart and start writing notes after an adverse event happens. And now most people start to think that there is some conspiracy going on, that the healthcare providers are now trying to cover up something that happened in the patient's care as a result of that negative outcome. So you want to be cognizant of that and know that most companies have records that track when you access the patient care records and what you do when you access them. Make certain you understand what your record policies are in your company. You want to review your record policies, make certain that you are up to date on them, and be careful with how you document. Some people engage in this practice of cloning. You are going to see a patient for 5 days while they're at your facility, and you clone your first record into your second record, into your third record, into your fourth record, but you forget to change things about the patient's care. Don't do that. If you are going to clone a section, well, maybe you want to clone the history of present illness section, but go in and actually change things around. Change your sentences around so that people know that you're not just duplicating a note from an earlier interaction. And make certain that the information is accurate. I can't tell you how many times I'll read a medical record and I'll have a doctor at a deposition. He'll be like, you know what, that's wrong. Because if you look at my earlier note, it says blah, 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 blah. Well, they engaged in the practice of cloning and forgot to make changes to the patient's records. Be careful of that. And some of you have default entries because you have templates that are produced by your healthcare facilities, and you have boxes that you check or are supposed to uncheck. Pay attention to those things because those check boxes and unchecked boxes can matter in terms of the things that you have documented in your records. And I know some of you end up in situations where you have these lists, and you can only check between 1, 2, and 3 on that list, but you believe that the patient needed something more specific. Write that in a space on the note. Find a free area in the patient's chart and document if you think that there is something specific or something unique about the patient situation that should be documented in the record. Here's my general advice. Don't, under any circumstances, alter, correct, delete, or make additional or explanatory comments in a patient's record without discussing the matter with risk management, especially after a sentinel event, an adverse event in the patient's care. They often say the cover-up is worse than the crime. Well, they usually mean that because you don't want to necessarily be in a situation where people are saying that you made these changes because of the adverse event. Oftentimes, risk management will involve lawyers in those situations, and sometimes I even provide advice to risk management professionals when there is an adverse event and there was something missing from the patient's records. Oftentimes, the risk management professional and the lawyer will agree that you might need to have an addendum or if you need to have a late entry, those might be okay depending on the circumstance, but you should make certain that you get some advice. It would be better to get things right the first time if you can, so that you can avoid the allegations of some ridiculous cover-up. Dictation. Some of us use dictation to help write our notes, and we forget to review and edit them. So Dragon, for medical professionals, doesn't always get it right. Sometimes there's transcription errors and things that don't really make sense. And so you want to make certain that you review your documentation and you edit the documentation as appropriate. Some do's: you want to use proper notations to prevent misunderstandings about patient care. Make certain that you're using the proper abbreviations. Some hospitals say don't abbreviate certain words because they're misunderstood. You want to use appropriate terminology to avoid errors and confusion. You should timely complete entries in the patient's chart. The same day is often preferred. If you can do things the same day, you won't have a backlog in terms of your records, and you won't forget stuff that's important to patient care. You want to document a patient who's non-compliant and document what actions you took to address the non-compliance. It's not enough to say the patient was non-compliant. You have to always say that you advise them that they should follow up, follow this advice, do those things that have been recommended. Don't. Typically, you shouldn't be writing negative, judgmental, or even subjective comments about patients and their families. They don't typically play well in front of juries, and here's why. They'll say you didn't give them good care because you wrote these negative things about the patient. Because you were mad at the patient, you decided to, write your negative review of the patient in the medical chart, and that's why you withheld the pain medication. That's why you didn't give them the support that they needed. And so you shouldn't necessarily write negative or judgmental things about the patient, but you should write objective things. Patient refused, patient combative about certain when you walked in. And you want to write those things down in the patient's chart and be objective and describe how the patient was being combative, because the patient was verbally abusive and said these words. Those are things that you should write down because those are objective. Not that the patient is a moron, not that the patient is an idiot, not that the patient, is stupid and won't follow don't write those things down. But you want to write down the things that would seem to be objective in terms of patient care. Let's talk about communication. We need to be able to talk. We should talk to whom and what should I say? Let's talk about some of those. Communication is key in the provision of healthcare provider services. I mean, we know that that's part of the whole job is to communicate with each other to make certain that we're all on the same team and we know what we should be doing or should not be doing in a patient's care. For nurses, one of the best things you can do is tell the physician about what's happening in the patient care and tell that physician often. No doctor's going to be like, well, I want you to stop bothering me. I don't care what's going on in this patient 304 room. No, you tell them and you tell them often because you're the front line. You are going to be the first person likely to notice a change in the patient condition and be able to talk with the doctor about what you can do to address that situation. And oftentimes it's better to tell the physician and then they say, well, just keep monitoring it and let me know if there's another change in the outcome. The second thing you can do is tell the patient within your area of expertise or your area of practice. I mean, some things are going to be beyond your knowledge or some things are better coming from the doctor than they may be coming from a nurse. And in those situations, let the doctor tell the patient those things. But there are things that you can do. Like if you're going to be injecting a medication, oftentimes it's good to tell the patient where you're going to inject them and why. If you're elevating the patient's head, it's a good idea to tell them why you're doing that. If you want them to get up and walk, tell them why. We need you to be able to do these things because it's going to help you get back on your feet. It's going to help you be able to go home. Those types of relationships between the nurses and the patients are gold because they'll start to trust you. They'll start to be more accommodating to those requests. And then the third thing you can do is follow up on test results. One of the big things that people fail in doing is following up on some of those results. As patients, we recognize sometimes we have to call and say, hey, I had a blood test last week. What were the results? I mean, I had a test last week. Tell me what happened. because some of us think that no news is good news, but that's not always the case. So make certain you follow up on the test results, make certain that things are coming back that have been ordered for the patient and that you're giving them what you're supposed to. How you communicate matters. I have been involved in a number of cases where nurses and doctors are texting back and forth to each other on their personal devices about patients. And I say, oh no, oh no, oh no, oh no, 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 no. Because there are some HIPAA privacy concerns about exchanging those types of messages. And then most patients' attorneys have gotten smart and they start asking the questions, well, were you texting back and forth with other nurses or other healthcare professionals about those cases? One, you really shouldn't be using your own personal devices to communicate unless your hospital or healthcare group has a policy or practice regarding that. I can tell you that text messages are discoverable, but phone calls, nobody takes a transcript of what happens in a phone call. So if you got to talk about a patient's care, pick up the phone, call them, say what you want over the telephone to the other healthcare providers, because there's usually no transcript of what happened to those phones. But those text messages, they can be damning. I have seen them happen that way in a couple cases where the nurse was texting back and forth about a patient's care, and it comes back to bite everyone in the derriere. So better safe than sorry. If you're communicating with a patient and you can't escalate that to another medical provider, send the patient to the ER. Every nursing triage note, every note that about an interaction with a patient about a complaint or condition should include the words, if you don't get better, go to the emergency room. If you're still feeling the same way in an hour, go to the emergency room. It's better safe than sorry. So always advise the patient when you're doing phone triage or telehealth, or if you're stopped in the store and somebody's asking you about a medical condition, go to the emergency room. Go to the emergency room. If you're ever in doubt, send the patient to the ER. Minor delays can have disastrous consequences for certain patients, particularly post-surgical patients, post-op patients, or even in an emergency setting. So I always recommend that you advise the patients to go to the emergency room and don't say wait till tomorrow or the next day. Tell them to go to the emergency room. You also have to be careful what you say. If a patient asks you a question that's better for a physician, let the physician handle it. You might know some things based on your experience, based on what you think, but remember, that could be speculation, and you don't want to give the patient false information about their medical condition because the doctor may have a different way of explaining that or saying something. So if you know that some things have come back for the patient's care, you might say, yeah, your CT scan is back, but I'm gonna let the doctor come in and explain it to you, even though you've been a nurse for 30 years and you've seen a ton of CT reports and you know what the words and stuff mean. It may not necessarily be in your lane at that moment to explain that condition to the patient. It might be better for the physician to do that. And so make certain that you stay in your appropriate lane when you're involved in patient's care, and be careful what you tell the patients about what you think stuff is, because they'll say the nurse said it. If the nurse can recognize it, then of course the doctor should have known. And so you have to be careful sometimes with what you think about patients' conditions. You have a right to remain silent. Everybody knows this. Anything you say can and will be used against you in a court of law. We call that the Miranda rights. And most of us think of that in a criminal case. But let me tell you, in civil cases, your words will be used against you. We call those admissions. So be careful what you say and to whom you talk to. That's why one of the things that I tell my clients when they're involved in litigation, never talk to the patient's attorney, always talk to me, because our conversations are protected by attorney-client privilege. You should consult risk management when you need it, seek legal help, and don't go at a legal process alone. We're all here to help and to do this together. So key takeaways from this presentation is that you should always remember CDC, continuing education, watch your documentation, and make certain that you're communicating appropriately. If you follow those 3 steps, odds are you're going to find yourself in a situation where you're minimizing your risk of being involved in a medical malpractice lawsuit. Thank you all so much.
Hey, thank you, Tony. That was great. I'm going to have you just switch off your screen share. Perfect. And we do have some questions that came in. I am going to give the panelists a chance. If you had any questions, I'll give you first stab at it, though. Go ahead.
I don't think I have any questions. I saw your presentation at the conference in the fall, and I think it's excellent. And today's just kind of reiterated what you had talked about then. So it's just the more you talk about it, the more I hear it, the more it's going to stick with me. So I appreciate it. It was a great lecture.
You're welcome.
All right, I'm going to go to the questions from our group. Mary Ann sent in this question. Are your assets protected if in a trust?
They can be, depending on how the trust is set up. As a matter of fact, most healthcare providers early in their career will start to set up trust as a way of shielding certain assets from malpractice judgments. You should always consult with your trust and estates lawyer and make certain that they are shielded or protected in a certain way, because you have to make certain that you set them up correctly. One of the things you have to watch out for is that you can't start setting up trust to protect your assets when you are involved in litigation. That's usually seen as a sign of bad faith, like you're trying to defraud the injured patient from those particular assets. The best way, in my view, to protect your assets is, one, to make certain that you have insurance. The second part would be to have a good trust plan.
All right, very good. Leo sends a question. Great presentation, valued and acknowledged. Question: what patient signs, symptoms, behavior, statement, red flags, example, different providers for the past 2 years, can be considerably a litigation high-risk tier?
Well, it really depends on the specific area of practice and the type of patient that you're dealing with. Oftentimes, you're going to see some patients are belligerent and they are overly demanding in certain areas. Sometimes, one of the areas I see it a lot is regarding pain medication. Like a patient says that they're in pain and they've just received their maximum dose for that particular time period, and they think that they're entitled to more, and you don't give it to them because you have a policy regarding that. And then they feel some kind of way about that type of interaction. Oftentimes people complain because they don't think that they're getting enough attention. Maybe the doctor doesn't come in enough and they get angry because they've seen the resident 3 times, or the nurses aren't making as many trips to their rooms as they would like. And those types of situations, I think it's looking to more so communication with the patient, reminding them that they could use the call button, or they could, ask you some questions, and making certain you ask them before you leave the room. Do you have any other questions? Is there something that you need that you haven't gotten? And those types of situations or questions sometimes diffuse the interaction between the patient and the healthcare provider. But some of us know that there are certain situations where you can't turn away patients because you might work in an emergency room, and if everyone walks into an emergency room, they're going to be seen. So you should recognize that. And then if you're in a practice where you know that you can't treat a patient, you should make certain that you give a written referral to the patient and document that in the medical file if you're turning that patient away for whatever reason.
Good. And this interesting question came up. Can you file malpractice against federal providers? I think they're like people who work for the VA, etc.
Yes, there is typically a limited waiver of sovereignty for the federal government. We call it a Federal Torts Claim Act. They can file lawsuits in federal court against federal employees for providing federal care. I have a few cases right now where that's happened. The majority of those happen as a result of prison care, but I recognize that there could be cases involving veterans and people who treat at the VA.
Good. We do have a compliment for you. Fran Foley said, "You're excellent speaker. You'd be a great one for our annual conference, our big SUNA conference." Well,
I'd be happy to join you.
Always put that out there for him. You did a great job. I can't thank you enough for being on. Here's some comments from Paula Wagner. I think makes sense. Be sure to note whom is with the patient at the visit.
Mm-hmm. That's smart. That happens. I love when I know that there's been a family member or someone else there, especially for situations involving informed consent. Sometimes patients aren't able to do it, and a family member or someone else signs. So it's good to have interactions with the family when they're there too.
Yeah, I think that the take home is you can't chart too much.
No, there's no such thing.
And then Paul also noted that surgical patients are high risk for urology. I think I did hear a comment that vasectomy was one of the more litigated. I don't know if you've heard of this or not. I'd heard at some meeting that was one of our more litigated things.
In urology.
Yeah.
And it's interesting because you never know what type of case you're going to get. Maybe it was a vasectomy that reversed itself. I know some people, and we have some ethical debates at our firm sometimes about these wrongful birth cases. Excuse me, because sometimes that happens. And I think one of the practice points that every urologist probably should tell a gentleman undergoing a vasectomy is that, hey, it could undo. I mean, there's a chance that it could, things could happen depending on the type of procedure that's performed, and never provide there's a 100% guarantee that this procedure will work. Because the body has a way of sometimes regenerating, and people are like, what?
Yeah. I think it needs to be in your informed consent for sure.
Yes, absolutely.
Yeah, that should be verbalized and also on the informed consent and on the explanation. As a matter of fact, if you go to my website, underneath one of the tabs about vasectomy, that specific point is made on that handout. Potential failure rate of 1 in 2,000.
Okay.
Yeah. And as far as documenting who is in exam room, so it could be in a hospital setting. In my situation, it's in a clinic setting. I document as part of my physical examination, because when I'm examining the patient, I document exactly who is in the room. So I see a lot of vasectomy patients, not just the patient is in the room, but the wife and also their son. I document that they are in the room when I document the physical examination. In addition, if I'm doing a surgery in assessment and plan, I write down all questions are solicited from the patient and wife, who is also present, and they voice understanding. You want to include that in context. And I think that's one of those defense moves.
It's a great practice point.
Also lets you know who you can call in as a
potential witness.
Who he said, she said. Now you got, and they said.
Those are all good practice points. Informed consent is often a big issue because patients often say, well, the doctor didn't tell me about the risks. And, some of our hospitals have standard informed consent forms that list the general risks, but sometimes there's specific risks to certain patients that don't end up on the informed consent form. It would be good practice to add those specific risks to a patient in a particular note. And so you make certain that not only did I discuss the standard risks, I also discussed the patient specific risks, and I documented that in the note as well. Those are just gold mines for informed consent cases.
What a lot of people don't realize is that informed consent is not that useless piece of paper that they have you sign at the hospital. That hospital's consent. Whenever I go to the hospital and I have to jump through their corporate hoop, which is total BS, jump through the corporate hoop and sign that consent. If you actually read the consent, you think the patient understands, or any layman jury is going to understand cystoscopy, bilateral retrograde pyelogram, ureteroscopy with laser lithotripsy? No. So that is not a consent. That is a useless piece of paper. That is administrivia. It's just another hurdle to keep you from providing appropriate care. What is a true informed consent is a procedure-specific informed consent document outlining the risks, the benefits, the alternatives, and prognosis without treatment, written in 6th grade level. A lot of people also miss that document is not informed consent. Informed consent is a process. It's a process, not just a piece of paper. I yield back to you.
That's an excellent practice point. I'd add to Dr. Lin on the backside is that what I find to be more useful is you can have the standard hospital informed consent, but in your note, when you say explain procedure to the patient, or you describe the procedure to the patient and you use the layman's terms in your note, that is belts and suspenders. You comply with the hospital's aspect of it, and then you explain the procedure using those non-medical jargon when you're explaining it to the patient. That's often very good. That's gold. We like to see that.
Very good. I'm going to bring one last question in because we are running towards the end of our session here. We did discuss this, I think, at our last meeting, which was on pediatric urology. What about having a chaperone present for the exam? I don't know if this is something that you encounter as defensive attorney or if it's more criminal law, but we were talking about how a female patient might claim that somebody, inappropriately touched them during an exam. You have thoughts on that?
I actually have cases like that. Usually there are OBGYNs or gynecology cases, male gynecology cases with male gynecologists with female patients. It would be better practice if you're in that type of situation to have a female staff member present for you. Some facilities mandate it. I can share some horror stories where a doctor was accused of inappropriately touching an individual, and she filed a criminal complaint. And the state's attorney's office the police department began investigating before referring it to the state's attorney's office. And the doctor was able not to be charged in that particular case because the female staff member was present. It was like, I was there the whole time. I saw the whole thing. Nothing inappropriate happened. And the second part of that, I would say, is if you're dealing with a situation involving minors and minors are having care, if a parent is available and can be there in the room, that would be good. And at a minimum, there should be a second staff member present in some circumstances, depending on the type of care that's being provided, so that you don't necessarily find yourself dealing with accusations of inappropriate care.
Yeah, thanks. That's really good. We are going to keep moving on because we are at the end of our session. I do like to keep things on time. I want to remind everybody next week we do have a great conference or another great program coming up on bladder cancer therapies given by our own panelist, Lori Atkinson. So tune in next week for that. Of course, if you didn't get enough and you still got more questions, you're more than welcome to go ahead and get to that after party. Just go over to our website, UroNurse.com, hit the big button that says after party, and you can bring your questions and concerns, or just want to talk about anything you want. We'll meet you over there at that. Again, I would like to thank Tony for his time. This has been great. I think this is something that we all dread that we could have this happen sometime, but it's really nice to have somebody that could really, I think, summarize what we need to do and make us, I think differently now when I chart to make sure that I'm always trying to put those notes that I want to cover all this stuff. And it's especially easier with electronic medical records because now people can read what I put in the notes.
It's very good.
All right, everyone, have a great day. And those of you that want to join us in the after party, we'll see you over there. Thanks for your time.
Thank you all.
Thank you, everyone.